Hello, everybody. Welcome to this month's Introduction to Construction Contract Administration. With that, I do want to hand it off to Jim to get started. I believe our other co-chair, Douglas, will not be able to attend today's session, so it's just going to be Jim and I. So, Jim, over to you.
Thank you, Matthew. Welcome, everyone, and thanks for rejoining us this month. As always, please use the raise your hand and comment chat box with Matthew so that he can get your questions out. These are always much more rich when you participate like that. So that would be wonderful. And we'll just jump right in, Matthew, and go to the next slide. There were a couple of slides that sort of finished up the resolving of claims. And if you go to the next one, we were closing in on the end of claims, which unfortunately often lead to disputes. And so I wanted to be sure and touch on these last two, closing out the claims discussion. So in the end of our discussion last time, we were talking about the claims we're in and what's next, because we had set up, really where they come from. And first of all, it's incumbent upon us as the architects or engineers to be sure that everything is documented properly, that we've received everything about a claim. That is, of course, the responsibility of the party making the request. And we need to be sure that everything is understandable. At that point, there's a preliminary response that may be appropriate. Maybe there's more information that we need. Maybe there's some other information that would be beneficial, and we would suggest in a preliminary response what a proposed solution may be, or what schedule we might establish to establish that resolution. And in some cases, many cases, these are easy. Claims are simple to understand, and they can be processed fairly quickly. Certainly that should be our effort as we remain fair and impartial to come to a conclusion with a claim and address those that are simple and easily understood in an expeditious manner. Depending on the type of project delivery system, we may require further documentation against which to compare our contract documents. If, for example, there's a unit cost involved with a claim, then we want to be sure and take the appropriate time to consider that and go through it, to look at the total impact that may be created, and as well, if there is some kind of schedule impact, then we would want to see that schedule information, but we certainly would want to take into consideration what that impact may be as we considered the claim. So let's go to the next sheet, because that's a continuation of resolving the claim, the next slide. And there may be these reasons that there is a claim in existence. There may be defective or non-conforming work. And in that case, then we might have to have some other agency involved with providing information to consider the claim, whether it's an independent testing agency or some agency that would measure some industry standards. Most likely there will be field observations involved so that we could gather information to assess the claim. There may be multiple parties that need to be present for that information gathering session, and we want to lead in a mutually acceptable way to gather the people and take a look at the right things at the right time together. I'm going to skip that last sentence there for a second and go down to saying then once all this is in hand, the architect or engineer is responsible for evaluating all this information, analyzing what's there for us to look at, and then rendering a decision that is a written decision to all the parties. And if it's not something that's acceptable, if negotiations are possible, that we can resolve the issue, these documents may be used for us to start that process. but sometimes that's not possible, and we move further into disputes. But one of the things that I was taught very early in my career about these the resolving of claims, if you are able to have communication and direct, honest, forthright discussion, there certainly are opportunities to resolve things. And my mentor suggested that having rooftop meetings when you're talking about issues on the roof is a much better atmosphere to have those conversations than meeting at someone's attorney's office to debate the points of a case. Always on the site, in the field, was a better atmosphere and a better arena for consideration of some claim. So I like to make that point. And as we go to the next slide, Matthew, let's see if there are any hands raised or anyone has some points to add.
Yeah, we had a comment came in here from our monthly fellow devotee here, Kevin. So Kevin says, in drafting a decision on entitlement and a claim, it's important to remember that the decision will probably be Exhibit A in the associated dispute. Impartiality is important.
Absolutely. Absolutely. Good point, Kevin. And that is our charge, to remain fair and impartial when we're doing that. So it's very important to be sure we keep that perspective. Any others?
That's it so far. Everyone starts off quiet and they get motivated by the end of it.
Okay. Yeah. That's good. That's good. So when claims are difficult to resolve, then it's common, and this becomes maybe more and more a part of what we do each day, unfortunately, but it's become so problematic and maybe so pervasive in the industry that there's actually a term now called claims avoidance, which is fairly common and applies to all of the management techniques that we may use while we're working on a project to try not to get to a dispute. So I hate that Doug's not here to make this statement because I attribute this line to him, but it's really important as we do our work to understand that we're sort of a rarity out there. Our industry is quite unique in the fact that it is assumed that there are going to be mistakes made. And our contracts, for the most part, are created in a way such that there are procedures to handle those mistakes. Now, that's not as well put as Doug Freeman would put it, but we plan to fail and we plan a way to take care of that failure within our documents. And so understanding that a claim is valid, understanding that perhaps there's not going to be resolution with that claim is going to move it into the next phase, which we define as a dispute. And it's important to understand how we go about taking care of those disputes. So there are some understandings that the various parties have or should have as we move through a claim process, and in an attempt to avoid this moving from a claim to a dispute. And let's take a look at the next slide. I think these are interesting statements and important to ponder. First, the owner needs to understand that the contractor can only include costs within a project based upon documents where things were reasonably inferred. So they're not clairvoyant. They can only look and see and price what is clearly there. At the same time, the contractor needs to understand that the owner is trying to control costs. Money is not unlimited. It does not grow on trees, and so they have to be cognizant of that. There's a schedule that's important to a project, and that is a part of the owner's consideration. The contractor needs to think about that. From the engineer or architect's perspective, we are expected to act in a timely fashion and need to understand that that's critical, that our timely response to issues is important, and that integrity and a sense of accountability raising your hand when you say, I made an error, I made a mistake, is something that's expected because we're to act with integrity. So I always say, don't do that without talking to your risk management people first. But these are important parts of our attempt as a package to avoid a dispute. When all those things are measured together and we're unable to avoid a dispute, then there we are in a dispute. What do we do now? Well, first of all, we are proactive. As with everything in our business, time is money, and it's important for us not to linger over, but to handle the process. So there are three things that are very important in this whole process to continue to manage a dispute, and then those are communication, documentation, and resolution, and figuring out what the action plan is to resolve the claim as it moves in this direction of a dispute. So it's a collaborative effort between the three major players of the team, the owner, the contractor, and the architect and engineer. We, as members, need to accept our responsibility and accept it quickly. And if we are truthful, certainly we're keeping our risk management company, insurance company, our legal representation involved with moving that process forward. But we need to do it in an expeditious manner. Concise, pertinent, accurate documents that contribute to the understanding of what's going on, that are legitimate, not frivolous, are all important pieces of the documentation of a process. So let's go to the next slide, Matthew, and see if there are any questions, and we'll talk about establishing a plan for the system.
Yeah, there was another comment that came in here saying rather than dispute avoidance, perhaps it should be referred to as claims avoidance, because by the time it becomes a dispute, it's usually too late for all this avoidance stuff.
Well, that's a great point. By the time it's become a dispute, you're right. And I think part of the reason that it's not considered claims avoidance is perhaps the debate over what a claim is. And we got into a little bit of that on the last call. And what is a claim? And I would use the word negativity that is related to the use of the word claim. Again, Doug has a very eloquent way to state that, a claim, it does not necessarily equate a negative or confrontational position, but could be as simple as just something that was agreeable to the parties, but was clearly not included or not reasonably inferable in the documents. And so that's a good point. It would be nice if we could avoid claims at all, depending on what your definition of that word is. And so maybe we define it here on this next slide as claim resolution. I think that it's obvious that time is an integral part of everything that we talk about in construction. And when claims do arise, then prioritizing those, being sure that you've got the information that you need to evaluate and resolve that claim leads to avoidance of it going further. Being sure that you're able to identify who's responsible and that you do have the authority to resolve or settle a claim represented in the room once those claims become a point of discussion are important to establish, to facilitate, to assure as a claim presents itself in trying to avoid it moving to a dispute. So we talk early in pre-construction, and we talk in monthly construction conferences about having representatives at the table that have the authority to make decisions, so that when you do have that rooftop meeting, everybody is there to say yes, 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 and you're done, and not have to go back to try to re-explain and reposture and perhaps move that decision further away rather than bringing it closer into completion. And if you've done everything that you can do, that you know to do, and you've not been able to resolve the claim, then it's important to realize that that point is there, to not belabor it, and to allow the claim to move on to the next step, which is a dispute, so that the initial parties that are going to resolve that dispute can get started with that sooner rather than later. So we're going to move into how we go into the disputes and where they come from and how to resolve those. But before we do, let's see if there are any specific discussions about claims that we ought to finish up with.
There was one question that's not specific to claim, but I'll offer it now, and you can decide if you want to answer it now or maybe later. It comes in from Hassan. Okay. He says, contract terms in the construction industry appear to accept the craft of an artisan. Given the increased mechanization and digital technology and modular construction in the fabrication shops, should the basis for contract terms change?
Wow. That's a really great question that I feel totally unprepared to answer right now. First, I'll say it certainly is a question that's going to be debated, and as we move further and further into, as you pointed out, for example, 3D printing, because removing the artisan piece and inserting in the mechanical piece certainly will move us towards in some particular ways, exact documents and exact results. So it's a really great question to ponder. Gosh, I know in what I do in my daily job, I see a lot of printing and making, and it is wrought with error. Typically that error is coming from the drivers of the equipment that's making it, but sometimes also the equipment itself. So I don't know, that there's a lot of discussion there. Maybe we should put that on the agenda, Matthew, for something to add to these discussions in the future. What does printing and making and the mechanizing of our work bring to the construction administration phase?
Great. I made a note for it. And we had another comment that came in here from Dean before we go to the next slide, just saying, what fiduciary duties fall to the AE, owners and product suppliers and contractors?
Well, that's a Doug Freeman question. I'd love to send that to Doug and let him answer that, because from his attorney background, that would be that'd be way more appropriate than me taking a swing at it. Could we do that?
Sure.
Could you send Doug and I, send us an email and copy Dean, and
yep.
Doug will love that.
All right, that's it for now. So we'll move on to the next slide.
So disputes. Gosh, I can't tell you how many times I've moved from claims to disputes, maybe simply because someone lost their objectivity and lost sight of what the original issue was, which I think goes back to feed our hope of being expeditious in handling a claim before it has time to fester into a dispute. They grow out of the simple fact that some of the people just couldn't agree and that the negotiations failed. Our documents, whether it's AIA or EJCDC, talk about and lay out a path forward for us to manage these disputes either by mediation or some other processes, failing agreement or resolution. That may be other kind of types of resolution, and we're going to touch on those. So these demands are made usually because, again, that we've failed to reconcile and come to an agreement. But there are certain rules and regulations for moving forward into disputes. Certainly within certain time constraints, there are limitations about how long we can have disagreement before certain times pass and we're not able to, contractors, for example, are not able to continue into a dispute if they haven't filed a claim by a certain period of time. So we also have constraints about how quickly we move into dispute resolution when those claims have been made. And I want to talk some about alternative dispute resolution because there are many alternatives to resolving the disputes. And if we take a look at the next slide, we'll start to disseminate some of those. So I guess we all sort of kind of start with the fact that litigation may be the least favorable way for us to resolve disputes. And why? I certainly have worked with people who think that it is absolutely the best way to resolve disputes, and I find that interesting. But we'll touch on some of the pros and cons of the various resolution opportunities that we have to go through. Certainly with litigation, the parties lose some measure of control in the process. It certainly can cost more money, cost more time. That may not be due solely to the parties involved, but just the legal system within the state where you live or the court system that you may be working your way through. So for various reasons, other methods have become perhaps more utilized in dispute resolution. And some of those are arbitration, where that may be binding arbitration. It's similar to litigation, but can be more expeditious. There's a panel of experts that are reviewing an issue versus a random set of jurors and a judge who may not have any connection with construction or design industry whatsoever. And so there's a demand for that arbitration, and there's a process. We'll look at some of the steps and a few more slides, and that process can be much more favorable to all parties. Another method is judicial reference, where a retired judge or an attorney who may be familiar with construction industry and design industry is sought out and seated for an expeditious decision process where they make a decision once the evidence is presented to them. And we'll look at these as we move through the various resolution methods. So let's take a look at the next slide. In addition to binding arbitration, there's also non-binding methods of resolution. Similar to the binding methods, but maybe less formal, less connected to direct law or application of the law by someone who, an attorney or a judge. And they may be better utilized because they have a much more business focus as far as settlements than a law focus, which is a connection to some case study or case law. So these methods, you see them there: mediation, non-binding arbitration, mini trials, and a dispute review board. So we're going to look at these in a little detail, but mediation is a neutral facilitator who helps with negotiations. Non-binding arbitration is another process where a panel of experts or an individual is seated to look at the case who understands design and construction, maybe appeal to other venues. If that does not work once the arbitration is concluded, for example, going back to litigation. There are many trials which are a more structured process where neutral parties or an expert listen and make a judgment in the case. Also, those are able to be appealed to other venues, and they also might be more based on case law if, in fact, there are legal representatives involved in a mini trial. And then the dispute review boards are typically a 3-member board. They are experts at construction and design, and they go through a systematic project review and look at the issues and then render a decision. So we're going to touch on these and just take a look at the big 3, the ones that are typically the ones that are more often utilized in our business. You take a look at the next slide. Those are mediation, arbitration, and litigation. So before we start into that, Matthew, are there any hands up at this point?
Yeah, we had a question came in here from Kevin and then a comment following it up. So are there any comments on alternative entities for ADR, whether it be AAA or JAMS or others? He heard that often price is a differentiator. Anything else between them? And then he put in entities like AAA, JAMS, and the DRB Institute publish their rules for ADR online in their free downloads.
So I know I can speak to the AAA. I'm thinking Kevin's talking about the American Arbitration Association. I have served as an arbitrator and have, I think Kevin, maybe you have too. I can't remember, but I guess I would offer this, and we'll talk about this a little bit under the arbitration tab here. I have found that to be the most suitable way, in my experience, predominantly because the people that are involved, again, based on my experience, are there for the right reasons. They are either engineers, architects, designers, contractors, or litigators. And I guess if I could be so bold as to say one defining thing about all of them is they're just displeased with the amount of time it takes to go through the litigation process. There are many similarities with arbitration. Documents are shared, investigations are done, witnesses are called and are used in a process to make decisions. But the folks are interested in resolution. They're not so much interested in extended time periods, they're interested in resolution. Having said that, what happens is with all the parties involved, and because resolution is the goal, I find that they're a little too permissive in extended periods trying to get everyone in the room at the same time. So we're trying to be fair, we're trying to be nice, and we're trying to get a date that works for everybody. And you have 18 people that you're trying to do that with. And so that makes things take longer. So I think there's been a time impact to arbitration that it was established specifically to not let happen. When they're single arbitrators, maybe the cases are a smaller issue or smaller monetary value, they seem to move quicker, more expeditiously. But I found the people that I've done this with to be there for the right reason. They're not there to make money. They're there to reach resolution. And also, I think to try to learn. They seem to be very objective, and as we'll touch on in a minute, they there's been this reputation of just splitting everything down the middle and calling it a day, and that has not been my experience either. I think in all cases that I've been involved with, it's been much quicker than any litigation. So I think much less expensive than litigation. But we're covering these items here, and I don't know if I'm answering, Kevin, your question or not. I hope so. Matthew, are there others? Any hands raised or follow up from Kevin there?
No other follow-up or questions at the moment.
Okay. Well, let's look at mediation. The first.
Actually, Dean just popped in here. I'm going to quick catch up before we go. It says, as an arbitrator for many years, I have found this to be a far better, efficient, and fair. My experience has been 65-35 in one party's favor.
There you go. There you go. Thank you for adding that, Kevin. I think you're right. Well, let's look at mediation, because we'll talk about some of the pros and cons of all these. Mediation is where a third party comes in to help the parties negotiate to reach a settlement. In a process, it's been through a claim that now is a dispute, and often we've decided that we can't talk to each other, so we stop. And this third-party facilitator is one that will help us reestablish that connection and that communication. What's interesting and an important part about mediation is that this individual does not make the decision. They don't say you're right and you're wrong. Their intention, their process, is to help us decide as disagreeing parties what that fair solution to the dispute may be. So they're a handler, if you will, sort of walk us through a process. And if you look at the next slide, to sort of take us through the step-by-step process, we're at a dispute. One of the easy things we can agree is who the mediator will be. That is easier than most think, because there are people, I'm sure, everywhere that you're practicing that are participating in this call, individuals who are respected by contractors, designers, engineers, architects equally. They're the greatest of character, and you're able to agree on them because they'll be fair and impartial. So in the mediation process, picking those people, my experience has been pretty quick. They would gather us together for an opening statement of setting sort of the parameters of how we're gonna move forward, and how they intend to assist us. Each of the parties would have some opening statement of discussion about what their perspective was. And after the opening statements, there may be some joint discussion, just sitting at the table, presenting your sides of the story. Most of the time, those don't bring unique statements. In my experience, some of that is just rehashing what we've tried to tell before. I think that good mediators are able to help us see that we are losing our objectivity. I keep going back to that word. We perhaps don't want to lose. We certainly don't want to admit defeat, or perhaps we don't want to admit it was our error in some way, something. Our risk management people and our attorneys that help us run our businesses have advised against it. Good mediators help us understand that this is going nowhere if we don't change our perspective and take a step, reach a hand out. And so as part of those joint discussions, that may start to present itself. And then at some points, that group may break apart and go into various locations, and then private discussions occur. The mediator may be in those private discussions with the particular parties as they're broken up. The mediator certainly is a go-between when things start to move in a direction, making suggestions back and forth. Many of you that have maybe been to a car dealership and purchased a car are very familiar with this process where you have a person you're working with and they go back to another person and perhaps they go to another person. And it's very similar in the mediation process where a party may be going back and forth between different rooms or different locations. And in that process, sometimes they discover a point of agreement, which is a place to start to move forward. And so they may bring that group back together for a final joint negotiation where you are able to find things that you do now agree on and are able to resolve your dispute, at which time there would be a closing and an agreement that would be documented for you to resolve, finally resolve the dispute. So let's take a look at the next slide, Matthew, before we have any questions, and talk about what the pros and cons are of mediation. So it certainly can take less time. It can be less expensive. These can be done in a matter of hours, sometimes in a day. They don't require an attorney. Parties have more control because they're controlling what they're saying and what they're doing. It can be totally confidential. It's not a matter of record in the court system. Because there are periods where you're separated, it's less confrontational, and often you can have creative solutions because it really is just the power of the people that have been contracted together from the very beginning. So those are the pros. What can the cons be? Well, if you don't come to an agreement, and I've been involved with those, then you don't get your money back for the mediator and you have to start all over again and go to some other process of settlement. So you both have to agree, and you both have to agree to the settlement. Sometimes that's difficult to do. And one other thing is if you end up with the wrong mediator, then that can have a negative impact on the outcome. And certainly you would, in a mediation process, want to be sure you ended up with the right person at the table. So that's an example and a little brief discussion about mediation as one of the regular methods of dispute resolution. Let's go to the next slide, arbitration, and see if there are any questions, Matthew.
Yeah, so we had information here from Kevin. He's jumping the gun already, talking about arbitration here. I've heard enough stories about arbitrators that render decisions based on their concept of fairness rather than based on the express conditions of the construction contract documents. Perhaps that's why many public owners seem to prefer litigation in a legal court, believing that they'll get a fairer hearing from a jury of their peers.
Well, I think it's a good comment, and I've been fortunate. I haven't served with individuals like that, and going back to the American Arbitration Association, they've done a lot of work to, I would say, pare down the number of arbitrators that are a part of the association, and perhaps that's part of what was driving that process. It's unfortunate if someone is applying their concept of fairness to a set of construction documents. Most of the arbitrators that I have served with have been very focused on the documents and very aware when their emotions were starting to become involved. My experience has been good with three-person panels because we were able to keep one another in check a little bit and not move in that sort of emotional, oh, this is what I think ought to happen kind of direction. So it's a valid point. It's a good point. We'll talk about the difference in the litigation here as we move into that third typical way that people resolve disputes. Arbitration is supposed to be an impartial party. Sometimes it's a panel, sometimes it's a single arbiter. They hear the dispute and render a decision. And you can decide whether it's binding or non-binding as you move through the process. Your contract may say that you have binding arbitration, that it's binding, and that that concludes the issue. There are many more contracts I'm familiar with do not have arbitration as a binding arbitration, but as a non-binding step in the process. So let's take a look at the process, Matthew, in the next slide, and then we'll take questions about arbitration. So again, this starts off with a good first step in reaching some agreement with people that are involved. They're agreeing to the arbitrators. If that's not possible, and I've had that experience, then different parties can pick an arbitrator to be assigned, and then if you're using an association, they may pick the chair so that neither party picks one of the people. And in an arbitration process, is very similar to court. The parties will present their evidence and their testimony. Witnesses can be called. In fact, in arbitrations that I'm familiar with, there are even subpoenas where witnesses can be subpoenaed. Different consideration and different legality of a subpoena from an arbitration board than from a court system, but still, nonetheless, it's a valid subpoena, and they can be examined, cross-examined in the arbitration process. And once everyone has finished their presenting the evidence and testimony and witnesses have been finished, then the arbitrators will go away to give consideration to the issue and render a decision and make an award. And that is a written award that they come back to present to the parties. That usually isn't at the moment, but happens as a follow-up once the arbitrators have had a chance to consider everything they've heard. And if your contract is inclusive of binding arbitration, then that concludes the dispute, and there is no other appeal route in binding arbitration. If you have non-binding arbitration, then you're not happy with the outcome of that arbitration. You certainly can proceed to litigation if you're not satisfied. So, in fact, Matthew, let's take a look at the next slide, and then we'll take the questions. I'm sorry. So what are some of the pros and cons about going arbitration instead of mediation, which we talked about first? Well, arbitration takes less time as well than as opposed to litigation, typically, and can cost less than litigation, typically. Typically, experts in the subject matter are involved, as they may be in mediation. So you're talking to your peers who understand the language that you're presenting. If it's binding arbitration, that can be a pro because there's no appeal, and that means the dispute is concluded. The proceedings, again, are confidential. They're not a matter of court record, and things can be more informal than they are in litigation. And another one of the pros is that you have some impact on the decision maker. So if you're looking at a huge, complex, multi-phase project, you may have people who are experts in that kind of project and project delivery method that you're using versus perhaps a personal residential issue that is perhaps a decision maker of a whole different kind that you may want to have involved. So what are the cons of arbitration? Well, if it's non-binding arbitration, then now you've paid to go through that process, and then you're going to turn around and pay to go through the litigation process. So that can be even more costly than if you had just gone straight to litigation. And maybe, Kevin, that's part of what the owners, what's the word I'm looking for, where they don't want to go into a method of arbitration, is that typically it's non-binding, and typically they're hesitation, is what I was trying to say, and they may feel like they're going to end up spending the money going to litigation anyway. But it also can be a con if you're on the losing side. If you're using binding arbitration, again, you have no appeal. Many feel like there's a tendency to split the baby on arbitration and just go halves and call it done. And so that can be a con, particularly if that is what happens. And as Kevin was saying, then they've applied the arbitrator's method of fairness rather than the application of the law. And as I was saying, if you have a panel and there are many parties involved, then scheduling can be an issue and it can delay resolution. And another thing is that the rules of law are not necessarily binding when you use arbitration. When you appoint those arbiters, and particularly if it's binding, then their findings are final and are not turned on the points of law. So that's a discussion about arbitration. Let's see now, Matthew, if there are any questions.
Yeah, there's actually a statement coming here. I think that'll work as a good segue into the last one, or the last couple of slides here. So the two most recent non-standard construction contracts that they've reviewed both have no dispute resolution provisions included. Instead, they set up that the owner's own people as the entity that unilaterally determines entitlement, claim, and disputes. Somehow, I think contractors aren't wild about that approach.
Yes, I think they're not. Wow. Well, that's interesting. I do think that one of the things that we should pay particular attention to when we're signing contracts is, or are the clauses there that appoint, for example, the architect or the engineer as the initial decision maker. And that can apply to a host of things, but particularly should apply to claim and dispute resolution, so that at the beginning you have the opportunity to make some decision. But it's interesting that that those documents I have not seen that give the sole responsibility to the owner to make the decisions. I can imagine that, and as I talk to my good contractor friends, they put money into their numbers to cover the potential losses that they may feel might come along in signing a document where the owner has the right to make the final decisions. I used to share with people, I worked in a firm that had a lot of construction administration individuals, and that's all they did. And contractors would call us and try to find out who was going to be the CA person on the job. And when you queried why, they would say, I have to add money to my bid because this lady's going to make me, or this guy's going to make me do everything that the specifications say. Well, I hope so. But, you know, they would put money in their bids depending on the person that was going to be there on the job to look at their work. So I could see contractors bidding those contracts that you described, putting money in their bids to be sure that they had it covered, particularly if they were working for an owner that maybe had a less than stellar reputation. Wow.
There's
That's
another
interesting. Well,
there's one more comment that came in here saying it may be worth mentioning that standard contracts of the AIA and the EJCDC do not assign the architect and engineer any responsibility in the disputes process. Of course, half the time the architect and engineer are dragged in anyway because of alleged defective design documents.
Right. Yeah, we all get an invitation to the party anymore, particularly if we have liability insurance coverage. It seems that's just a shotgun invitation. You're right. Well, one of the things when we talk about this, that thank you for going to the next slide, Matthew. One of the things that I'm very familiar with and believe heavily in is a robust set of supplementary general conditions, particularly if you have owners that you do repeat business with, that you've built some monicum of trust and reliability. The more robust those supplementary general conditions, I think the better for us as designers, for writers, producers, authors of the specifications, because you have an opportunity to go into the finer details of how these kinds of things are going to be resolved. And if you have clients that are open to that, I certainly would advise you to take a look at doing that. Now, you can get yourself in trouble, certainly, if you're not very aware of what you're doing when you write those expanded sections for the specifications, but they've certainly been handy in my experience. So the last of the three we'll go through, and then we'll have time for questions here when we finish, it looks like, is litigation. So here, we're all familiar, probably you've seen enough on TV, a judge and a jury hear the dispute, and they render a decision, and that decision is very purposefully based on the law and the facts at hand. Particularly in construction, there is so much case law for so many different things that can happen on a project site. There's a good possibility that there's case law around the country to apply to just about everything that goes on in our business. Now, the point was raised earlier about 3D printing. I guess some facilities are starting to be. I guess there'll be not far behind that some case law about 3D printing of facilities. But let's take a look at the process, which is the next slide. So what happens here in litigation is one party sues another party. So each party then has an opportunity to go to court to present their evidence and their testimony, their perspective, their side of the story. And in that process, just like as in arbitration, witnesses can be called, subpoenas, a very different thing in the legal system, are issued, and people are called to be cross-examined or to give testimony. And once that is concluded, then a judge or a jury render a decision, and they make an award, and that's pretty much final, unless there may be an appeal process because the judge in the case made an error, which is rare, but it happens. So typically, once litigated, then the dispute it comes to a close. So let's look at the next slide and talk about some of the pros and cons of litigation. So one of the pros is it certainly is a motivator to settle. When things are going into litigation, then it's a motivation to get things done. And you see this over and over and over again. If any of you have been involved with any kind of expert witness or deposition processes, just the shadow of litigation will move people to accept things and make up their mind and get a decision made. And if you do litigate, then you're sure that a decision will be made. They're enforceable. They are based on precedents around the country or in your local area. They're based on certainty and things that have occurred before and litigation that has occurred before. And the pros of it are that there's a very detailed discovery process that may even reveal more things that you want brought to light than you were able to get your hands on otherwise. So there's no forced discovery in these other it shouldn't say arbitration pros and cons, it should say litigation. I apologize for that slide, but in arbitration or in mediation, there's discovery that doesn't exist in those methods that does in litigation. And the cons are that it could take months or even years. It can be very expensive to litigate, certainly strains relationships within firms and between owners and customers and contractors. Often it's decided by non-experts, people that may have no information about design or construction whatsoever. And one of the things that I find that leads maybe more often to settlement than other things is that the people that are involved are not interested in this being public information. And often what happens in the court system is open to the public domain and is public information. And so airing of your laundry can be on the 6 o'clock news very easily. So let me stop there and see if there are any questions about litigation.
Oh, there's a comment, or actually 2 questions or comments here. One, it's probably worth mentioning that when it gets to dispute resolution, attorneys lead the way, not necessarily the architect or engineer. And then commenting here, because my employer's claims consulting group says that discovery is the most expensive part of the whole disputes process. Last week they gave a presentation about how to handle plowing through over 1 million documents in discovery.
Wow. That's true. I would be interesting to get Doug maybe to do an entire presentation on the discovery process, and certainly would give us pointers on things that we would not want to say, or ways that we would want to act, or documents we'd want to have in our office files. Any others, Matthew?
No, at the moment everyone else is pretty quiet.
Cool. Well, I'll hand it back over to you, sir.
But with that, Jim, thank you for your time. All your attendees, thank you for taking time out of your work schedule to join in and add comments and conversation, and we look forward to talking to you next month. So thanks, everyone. Thanks, Jim.
Take care, everybody. Thanks, Matthew.
Bye, everyone.